Hello everyone and welcome to the CEDR Masterclass on working with lawyers. Really delighted to have you all join us today, both in the room and also if you're joining us online. My name is Frederick Way, I'm the head of the CEDR Foundation. I'm also a mediator as well, and I'm really delighted to be joined by 4 colleagues from the CEDR panel today who are all commercial mediators, but also have been practicing lawyers or still are practicing lawyers as well, to really give a perspective on how mediators work with lawyers, but also if you are a lawyer as well, how you can most maximise value and from a mediation. So that's sort of that real dual element to that, and it's a really interesting and exciting topic. The way that the session is going to work is that we will have a conversation with the panel, and I'll introduce them in a second. But looking through a mediation from the early stages, sort of preparation, what you're doing even before the mediation starts with the lawyers, how as a lawyer you can maximise that, through to the early stages of the mediation, exchanging information, all of those sort of the challenging parts of it, onto bargaining and offers as well. If just a bit of housekeeping to say, we are recording this session, so it will be available later as well if you are watching in person online. We'll also be doing Q&A at the end. So if you're in the room, you will obviously be able to say your Q&A. If you're watching at home, please put it, and you have a question, put it in the chat. That will go to the host, and we'll be able to answer some of those questions at the end as well. I should have done this earlier, but I just say, really delighted with the 4 mediators that we have today. So I have to my left, Emma Gooding, Suzanne Tager, Andrew Manning-Cox, and Amrik Kandola. And I was just going to I was thinking about this. I could do an illustrious telling you who everyone is, but I was going to actually ask my colleagues if they would just explain briefly who they are as well. So if I can start with Emma to explain who you are.
Yeah, absolutely. Thank you, Frederick, and lovely to see you all here this evening. So my name's Emma Gooding. I'm a commercial mediator, but I didn't start out that way. I started as a commercial litigator with Allen and Overy in London, and then with Herbert Smith in Hong Kong. In 2008, I qualified with CEDR as a mediator, which was a really long-held ambition, having been passionate about mediation since I first saw it on qualification, and about the time of the Wolf reforms, which does age me slightly, I realise. So I've been mediating for a while now. I'm super passionate about it. For my sins, I also have 4 teenagers at home, and as you can imagine, most of my most difficult mediations have been conducted in that domestic environment. So I'm very well versed in how to deal with difficult parties.
Thank you, Emma. Suzanne.
So I'm also a full-time commercial mediator now, but my background is similar, I suppose, to Emma's. I trained at Watts Lovells and then became Hogan Lovells, and then worked in one of the commercial litigation teams there for 14 years. When I was there, I focused on banking, finance, and contentious insolvency, and also kind of director, shareholder, JV type disputes. And that tends to be the type of mediations that I deal with, just basically building on the background that I have in terms of the expertise. I also mediate a whole range of other disputes as well.
Thank you. Andrew.
Yes, thank you. Andrew Manning-Cox. Wolf reforms, we've just been talking about the Wolf reforms, and this lady in the front seat was part of the Rank K team where we did our training on Wolf reforms, which I headed up actually when I was about 14, I think it was. And it's great to have that memory. So we're going to catch up later. This is a fantastic evening, and thank you to CEDR for putting it on. So I'm a mediator. Obviously, I was on the board of CEDR many years ago, actually for 10 years, and it's one of its many formative stages, which was always an excitement as the Wolf reforms came in. So a great proponent of mediation. I'm also a chartered arbitrator. And I was senior litigation partner at Gowlings, which was the new manifestation of Rank K, up until my retirement about 4 years ago. Since then, I'm doing various non-execs and arbitrating and mediating. I'm also happens to be a notary public, but that's entirely irrelevant for the present purposes. I don't get any disputes as in that capacity. So it's a great pleasure to be here.
Thank you. And finally, Amrik.
Hi everybody, my name is Amrik Kandola. Like everybody else, I was a lawyer in private practice for many years. I trained at Eversheds and stayed with Eversheds for just over 25 years before I left in 2016 to set up what is now my mediation practice. And I've been mediating ever since. But I didn't actually mediate while I was at Eversheds, even though I did my CEDR accreditation in 2001. So I did my accreditation on the basis that I thought that would make me a better lawyer representing parties and clients. And I think that kind of worked. But obviously now I focus on mediation full time. At Eversheds, I was a construction and engineering lawyer. So that kind of follows me in terms of a lot of the work that I do as a mediator, but I do most commercial mediation out there. But I would say probably half of my work, if not more, is construction and engineering related. So anything either above ground, on the ground, or in the ground, or above the sea, in the sea, it's kind of, which is infrastructure based, it's kind of what I tend to do quite a lot of. So that's me.
Thank you, Amrik. So without further ado, let's dive in then. And I'm going to start, Andrew, by asking you first. Overall, just sort of thinking about, you've obviously sat on both sides of the table. How does a lawyer add value to mediation, and sort of how does a mediator work with a lawyer to do that?
Okay. I think that the key thing for me is to work out where you start and finish as a litigation lawyer in a mediation context. So I would say it starts with the persuasion, unless there's a contractual term to that effect, that you need to say to the client, this is a case we should mediate. And we've got the Halsey appeal, getting up, which involves Halsey in October, I think. So that could change that particular scene, couldn't it? And so you're in a situation where is this an appropriate case for mediation? And you can have a debate about when is the appropriate time for mediation. I think CEDR would probably say there's any time is an appropriate time for mediation, and the earlier you have it, the better. Choice then of mediator is really important, and I know that can be taken out of your hands by a contract term or by the fact that you can't agree identity of mediator with the opponent. And then it's preparing for the mediation. So there are various P words I'll use during the course of today, my guess is, which is preparation is key. It sounds slightly boring, but preparation leads to success. You can have a question mark about what success means here. But as a mediator, I would always say to people reaching a resolution or about to reach a resolution at a mediation that I'm conducting, I would say success is not, I won that, or defeat is not, I lost that. Success is in the morning. That was when I review what I did the whole of the last 24 hours or whatever it may be, that was the right thing to do. And I can get on with my commercial life. So it's preparation, the lawyer talking to the client, persuading the client, or making sure the client is aware of how this process is going to work. And lots of clients are very experienced now in mediation. It's a very mature product. Getting the aims and objective clear from the start, and then thinking through who your opponent is, who are they going to be pitching up at the mediation with, having a pen portrait in your mind about what's motivating them. You know what's motivating your client if you're doing the right job, and we all in this room will know that. But what's motivating them? What are the buttons we can press in that process? How can we use the mediator as this person on top of the wall who can see and hear what everybody in each room is saying and thinking, but we can't, as lawyers, see through that and hear through that? How are we going to make best use of that power? Because it's a huge privilege to be a mediator on top of that wall. And
how do you do that then as a lawyer?
Well, I think it's understanding the case, it's understanding your client and what their commercial aims and objectives are. I mean, we're talking commercial mediation here. And if you're not understanding it, then asking the questions to make sure you do, and then you've got your pre-mediation meeting with the client, pre-mediation discussions with the client, and then it's how do I play my first conversation with the mediator? I guess we'll talk about that in a bit. So preparation, what are the aims and objectives? How can I use as a litigation lawyer in a mediation context? How can I use the privilege that this creates, not capital P, but small p, it does have a capital P as well, to then get the best result for my client?
And so that sort of working with the mediator and really using the mediator, you sort of talked about and getting, this person's got privilege, you as the mediator obviously had that, and you sort of experienced that. What is the right attitude, or how would you approach the mediator for best effect?
Well, it starts when you have that first conversation.
Yeah.
So you've got the mediator on the call, on a Zoom call, on a Teams call, whatever it may be, and he or she has read into the case, let's assume at that stage. This is all becoming more and more just in time in my experience. So this can be a very accelerated process, and you've got to watch that. But there are good parts of it being accelerated as well as challenges. So you've got that conversation going. You've tried to understand what the aims and objectives are, because it won't come out from the case summary typically. And you're trying then to begin, and the mediation starts at that time, actually, before even the parties are in the mediation room. You're beginning to understand what are the pressure points here, what are the personalities, who is actually controlling this from the client's perspective, client A or client B. What are they going to feel like in the morning if they have sorted this out or not sorted this out? All those sort of things are in your mind as a mediator. And it's a fascinating process, but don't become a formulaic. One of my key messages for today would be, because we've all seen a lot of mediations, and of course CEDR has been at the forefront of those over many years. Training goes on, etc., but it cannot be a formulaic process, because you lose your audience at that stage. Equally, you can't, as a mediator, force people down a particular avenue. They've got to feel that they're fully involved in the process. But if there's one message I wanted to give tonight, it would be, let's not have formulaic mediations.
So adjust it, don't be formulaic, hearing that loud and clear. Make sure that you're sort of having that sort of early engagement with the mediator, talking to them, using them effectively, just sort of on preparation. I mean, is there key information that you think a lawyer really should be giving the mediator? This will, as a mediator, this opens it up. As a lawyer, this helps already the mediators to understand.
Yeah, that first discussion between mediator and lawyer typically won't involve the lawyer's client.
Yeah,
typically. I mean, it may do. That, I think, is an opportunity. Not that I'm suggesting the lawyer will then give you information that he or she would not want the client to hear, because that would be totally unprofessional and doesn't happen. But when you're not, quote, performing, unquote, in front of your client, which you are in a mediation context, to then have a face-to-face over a Zoom call, or indeed in person, if time allows, with the mediator, is a great opportunity. Some lawyers will be very much on the defensive. This is a process. I don't want to give my cards away too early. I don't want to give my cards away at all. And you can't force anybody to do that. Clearly, it's a voluntary process. But many other lawyers, and in particular in the bigger cases and the bigger firms, know that they've got to make some progress here. They know that they've got to empower the mediator by knowledge. Yes, confidentially, yes, without prejudice, yes, off the record, but empower the mediator to realise, from this area on top of the wall between the parties, this is actually what's making this particular party tick. And these are the issues that they're mainly concerned about. And they may have nothing to do with the way the pleadings have gone. So developing that relationship starts with that first.
And so do you feel you can be, I mean, you pick the mediator, and that the sort of, as the mediator as well, you're working with a party, can you be asking for this? I mean, how you're saying be confident in giving?
Yes, I mean, the mediator nowadays, the mediator is quote required, unquote, certainly encouraged, certainly in the CEDR mediation, to make that initial approach to the two sides, or three sides, or five sides, or whoever it may be. And again, that should not be formulaic. So in other words, if I feel and time permits that I can have one conversation and then another conversation with those people, with those clients, then I'll do that, because I always say to them, the mediation is starting now. This is a confidential, without prejudice discussion, one-to-one, and you're going to help me understand what's your aim and objectives in your camp, and I'm going to be able to have a similar understanding when I speak to your opponent. But of course, that's confidential unless I get authorized to release information. And let's all start the mediation now. So the joy of that, if joy is the right expression, is that when you get to that mediation day, you've already made a lot of progress. And you've got confidence building going.
Thank you. And thank you, Andrew. Just asking actually anyone else, is there anything just on preparation, sort of almost before the day, that is just a key move or killer move that a lawyer can make, or that you would do? I mean, I don't know anyone. Amrik? Oh, sorry.
Whether it's a killer move, I'm not so sure. I mean, I take on board what Andrew's making about preparation, and I think the mindset that I tried to have when I was in private practice was, what can I do with the mediator pre-mediation that's going to make the most effective use of time on the mediation day itself? So an example of that, I did one last week where there was a big issue with experts, and both parties had experts, and the danger was that if they weren't careful, the mediation day was just going to be overrun by experts meeting, and how do you deal with that? And it was really interesting that the lawyers came up with this idea of saying, well, okay, why don't we have Amrik meet the experts 3 days before the mediation? Now, that came from the lawyers, not from me. But what it did was it stripped out a lot of noise from the mediation day, because all of a sudden you've got the output from that experts meeting, which I was party to. So I was able to kind of nudge and caress and ask a few questions where I thought it was going to be helpful, but let the experts do their job. But then they report back to the lawyers, and the lawyers can then all of a sudden really focus on their clients at the mediation and not worry about having to deal with what it could have been a sideshow if they weren't careful. So that for me was part of the preparation work, and how lawyers thinking outside the box really make a difference, and how you best use the time. And that case did settle. So
thank you. Thank you. I want to bring Suzanne in now, we're going to be talking about joint sessions, but also just in terms of preparation, is there particularly, was there a comment you were going to make about that, or sort of value add?
I mean, I think that we're talking about pre-mediation sessions, and I think that they are key and really important, and they do allow you to kind of hit the ground running if you're able to use them to their optimum advantage. And one of the things that I always set out in the first email that I send once I've been instructed is, some points that we'll be discussing in those pre-mediation meetings, and one of them is joint sessions.
Yeah.
And whether we're going to have a joint session and where we're going to go with that.
I wanted to ask you about this. So joint sessions, so we've been talking about it, it comes up a lot about, and client reluctance to sometimes have them. Are they worth it? And sort of there are different views, but sort of you what is your view, Suzanne?
So I mean, having a joint session is a great opportunity in a mediation, because sometimes the parties have not been in a room with each other for a really long time, and they've not spoken to each other directly for a really long time, particularly if lawyers have been involved. And so they can be an opportunity for one party to communicate effectively with another, either the client speaking or the lawyer speaking, and to influence them. Because in a mediation or in a negotiation, so you've got an opportunity within that forum to potentially really influence the other party. At the same time, they can be a scenario where you are speaking to the other side, but maybe somebody's being quite accusatory, and in that kind of dynamic, ultimately somebody won't listen to what's being said. They will just work out where they can pick the holes and be defensive. And then, do they present an opportunity, or do they actually, risk derailing the process? And are they then, in that kind of scenario, better to avoid?
And so, just sort of on that, how are you determining that sort of scenario? Are you sort of with the lawyers talking about it? How are you determining whether or not they could be derailing the mediation or unhelpful?
Yeah, so I mean, I was looking at what I do in practice, because we've discussed this, as you would imagine, in advance. And I worked out, I think 50% of the time I have a joint session where people speak in a substantive fashion beyond just me speaking. I think around 20% of the time I have a mediation where everybody introduces themselves, but I'm the only person who really talks. And then around 30% of the time, we don't have a joint session at all.
Yeah.
And then I was trying to work out exactly how it is that we reached that decision. I mean, look, I think mediation presents a great opportunity where you've got time to pause and say, okay, what's happened up until this point has happened, and we actually get to play a role in shaping what will happen in the future. And you know, as you said, the first kind of step in that is appointing the mediator, maybe, or even agreeing that you're going to mediate. And then once you've prepared your documentation that you're going to send to the mediator, I would always have read it. And then I'll have that meeting. Ideally, I have a meeting with the lawyers and the clients as well. And one of the things that I encourage the client to do is to tell me what's going on. And I get to hear what they might say if they were to speak. But I also would ask the lawyer what they think is happening, and they will also, you know, have an opportunity to talk me through. And by that point, I usually have read the mediation statements, and it begins to create a picture for me. And I also will be discussing with the lawyer, because I said I'm going to, whether we're going to have a joint session, and they will give me their views on what they think. And depending on how all those different things come together, will give me a sense of whether I think somebody needs to speak because it's going to be really cathartic for them, because they need to get something off their chest, and whether the other side is going to be receptive to that and it's going to move things forward. Whether it's going to be an opportunity to present a witness, which might be quite useful for them to do. You know, there's all sorts of different things that people are seeking to communicate that might be able to influence the outcome of events in a positive way. But equally, if there's going to be a situation where people are going to be accusatory and they're going to find it very hard not to, or where, you know, I deal with disputes sometimes where somebody's been accused of a breach of fiduciary duty, for example, it's quite hard to have received correspondence from a lawyer in respect of that, and that's not how you see yourself. And then to sit in a room with that lawyer and have them say it again when you're there, in those kind of scenarios, you know, it doesn't kind of make sense to anybody that they would have a joint session. And so in that kind of situation, we would collectively decide not to. But that's the key, it's collective. They're giving me their ideas, the lawyers, parties themselves, the clients are often giving me their view to the extent that they're informed enough to do so. And then I sometimes steer them in different directions, but I would never kind of make the decision on my own.
And so this is sort of just a very active strategic decision. You're sort of saying you're doing this obviously in advance as well. It's not sort of something on the actual sort of a decision for strategically.
Yeah.
I was just going to ask you on the mediations, therefore, where you do not have a joint session, how do you work with the lawyers and the parties to then they still build that momentum and report, you know, and rapport may be the wrong word, but like ability for them to have a conversation with each other and sort of get to a resolution? What's the best way to do that?
Well, look, in those kind of scenarios, it's sure shots of diplomacy, isn't it? Because they're having a conversation with one another through you.
Yeah.
And in that situation, if I'm having a joint session, then we would have a bit of ground rules, invariably, where you kind of say what's happened in terms of what you signed up to in the mediation statement. I always say to the parties, if we're going to not have a joint session, even where you introduce yourselves, I will have to do it in each room, which maybe it's not the best use of time. And then also we would be having a conversation that I suppose continues from one we've already been having, because we've spoken before and we've worked out, you know, where things are. Previously, I asked them to update me on anything that might have been happening. And then in the same way, to some extent, as we would be doing if we went back to our rooms after the joint session, we're working out if there's information they would like to share, if there's questions they'd like to pose. You know, we're still working out where they want to go from there so that they can move the process forward. And you know, if they want to reach a resolution, which is usually what people want to do, but not always, then working out what the first few steps are together.
Brilliant, thank you. Emma, can I bring you in? Because what's your view on joint sessions and their use and how have you sort of seen it work?
I agree with an awful lot of what Suzanne said, which I'm sure won't surprise any of you. So for me, I think that joint sessions can be a really powerful tool in terms of getting the parties to speak to each other directly, or their lawyers. I won't usually impose it on the parties if they're very opposed to doing joint sessions. But I will explore the reasons why they don't want to do it. I think it's really important for me to understand that. And I will gently try and persuade, because I do find joint sessions can be really productive. So firstly, it's a really good use of time, which Suzanne has mentioned already. It takes a lot of time to be delivering the same messages in both rooms. So it's more efficient to do it that way. And also it can be such a valuable opportunity for the lawyers, yes, but also the parties to speak to each other directly, potentially. Often you'll find some reluctance about that. It will be the lawyers who will take the lead, as you know. But I do explore, just like Suzanne does beforehand, how that joint session might run, how we can make it comfortable for people, and also whether the clients would like that opportunity to speak directly to each other, talk about the benefits of that potentially.
And just something, I mean, we talked about earlier was that lawyers can sometimes, I don't know, I'm sure there are no lawyers who do this, but, you know, sometimes you have a reluctance or hesitation that your client might say too much in that session, or like, you know, give away the farm, etc. And or you know, what's your experience of anything like that, of being concerned about whether your lay client is going to say too much?
Yeah, so absolutely, I've got a couple of illustrations for you. So the first was a client speaking directly to the client on the other side. So this one came out of a minority shareholder dispute, and it had got very, very messy. So it was those kind of fraud type of allegations that Suzanne was previously. The claimant came in, his lawyer spoke. It was a fairly aggressive opening statement. And then the client turned to the client on the other side and he said, "I'm just actually really sorry that we're here. We had a really good relationship. I'm sorry it went wrong. I do feel like I have a valid claim, but there was definitely fault on both sides." And just that honest face-to-face communication, an acknowledgement that there had been fault on both sides, and a reminder that at one point, not now obviously, but at one point things have been good, was enough to completely change the dynamics of that mediation. It doesn't always work, but in that situation it really, really did. And so that's one situation where I think having clients speak directly was really beneficial. And then you've raised a really good question. I know it's a good question because it's how I felt when I was in practice, a little bit nervous about having clients speak directly at the joint meeting, because you don't really know what they're going to say, or they tell you what they think they're going to say and then something else pops out sometimes. Or you worry that they're going to make concessions which are going to be unhelpful, either in mediation or, you know, in the long run, if ultimately you don't settle. And I really do understand that nervousness. But what I would say is that it's a good idea to keep an open mind. And I've got another example for you, which is a case I did quite recently. It was an IT dispute where a big piece of software had been developed. And the corporate client who was being sued, that the software had been developed for, came into mediation. He was with his in-house lawyer, so he was legally represented, albeit in-house. And he said, unexpectedly from her point of view, "Look, I'll pay you if you can show me that this software works." And I could see the in-house lawyer stiffen, because this wasn't what she was expecting. As far as she was concerned, that was a concession that money was owing, and something that she wasn't ready and wouldn't necessarily have recommended say. But actually it turned out to be really, really helpful and really powerful in that mediation, because it gave us a way forward. So we had a process that we could go through and work out if there was a payment that indeed could be made. I had anticipated, and the party certainly had, that we'd spend most of the day separately doing a shuffle type diplomacy and exploring that way. In fact, what we did, once I checked in briefly with them, is that we spent pretty much all the morning together, going through the technical specification against the software and working out exactly what did work. And it was so helpful, because actually at the end of the day, the corporate client was able to say, "Okay, I accept, I do owe you some money, I will pay you." And he ended up paying a lot more than he had thought he would, because we were able to take a route that he had steered us down and we've gone with.
So you've gone with the lay client, really opening that up and doing that and letting that work. And I think just interested, so as a mediator, I mean, obviously you said you slightly recognise some sort of, this isn't going necessarily how everyone in the room thought it might go.
Yeah.
How, So sort of working with that individual, work just generally, how would you sort of approach that as a mediator to work with somebody who, are you saying just go with it, or how should they handle it?
So I think it's really important to be careful that everyone's comfortable with it. So I totally endorse what Andrew's saying. We should be fleet of foot, we should be innovative in our processes. But I wouldn't have suggested doing that in the joint meeting. So what I actually did is I took both of the parties into their separate private rooms. I checked in with them. I said, this is a suggestion that's come up. How do you feel about it? How can we make this feel safe at work and hopefully come up with a productive answer? And as soon as I'd made sure everyone was comfortable and we'd separately agreed process and ground rules for that, then we were able to get back together.
And let me just give you the other sort of scenario of you are the lawyer and your client has just said a clanger or something when they are just ignoring a major point. What should the lawyer do at that point with the mediation? I mean, what would you encourage the lawyer to do in mediation?
It's really tricky, isn't it? Because the temptation obviously is to step in, but is that necessarily the right thing to do? I'm not sure. So obviously we bear in mind that there are protections in place, and mediation is confidential and without prejudice, we know that. But then, you know, the other tension is the information's out there, and if we don't settle, it's still out there and can potentially be used, albeit indirectly. So it is difficult. So for me, as a mediator, I really like it when clients disclose because it helps me do my job, but I can see why solicitors might be tempted to shut it down.
And I think there is the opportunity always to just talk to the mediator and sort of say, and sort of clarify that point. I think I want to bring in everyone, and we had a conversation before we did this about sort of lawyer tactics, and especially, and I'm sure everyone listening to this is a wonderful lawyer, but it's sort of, you never know who's going to be on the other side, and sort of dealing with, you know, tactics, challenging behaviour, anything. I just wanted to open it, throw it out to anyone actually, on terms of if you are seeing tactics on the other side, or if you're seeing sort of things and you're sort of, you know, or challenging behaviour, what sort of strategy should you take as the lawyer and sort of working with the mediator? Does anyone want to answer that question? Andrew, go for it.
I'll have a crack at it. I think because this is now a mature product and people are more and more experienced and have more and more confidence in mediation, that then brings with it more and more games that sometimes can be played in a mediation context. I'm sure that it isn't reflected in this room at all. But, you know, we're all trained people and we know these things happen. In my view, the more as a mediator you can head off an issue before it becomes a party personal issue, the better it is. What do I mean by that? So if you are in your introduction, in your first interface with the parties and their lawyers, particularly when you're making that call that I was talking about earlier, if you can lay down some ground rules from your perspective, not prescriptive, because you have no power to lay down ground rules actually, but to make progress. This is how we're going to be putting ourselves in a better position to make progress. Then that gives you a signal to go back to if problems arise. What do I mean by that? I'll give you an example. So you are having an opening session, let's assume, which I think is in principle a valuable thing to do, because the parties may never have met each other in the past, or at that level in the business may never have met each other in the past. So in principle, a good thing to do. Different variations on that, which we can come to in a moment perhaps. But if you said, look, I'd like you to make an opening statement. I don't want this to be aggressive. I want this to be a constructive process. We've seen the case summaries. I want you please to confine your comments to what you have gained from the other side's case summaries. And if I feel that this is going off the rails or is becoming a counterproductive conversation, then I shall say so. Now, if you as mediator have said that early and not responding to party A when they have gone off the rails, then it does seem to me that you're preserving your independence, you're preserving your role. And in particular, that's important right at the start of a mediation, because they don't know you necessarily. You have come in, you may have been appointed by e.g. CEDR because they can't agree between themselves. And you have therefore a need to have speed dating credibility in the eyes of all the parties to it. So if you then leap in and say, well, I don't think Mr. X or Mrs. X, that's terribly constructive, then you may lose part of your audience on that basis. Whereas if you said, this is what I want you to do, please, I can't require you to, but I think this is going to be a constructive process. And if I feel that people are going off the rails, and you can see that sometimes from the case summaries, can't you? And you can see that from the pre-action correspondence that there has been. This is a really head-to-head issue. Then you've got some hook as mediator on which to hang an intervention. But hopefully, I mean, I'm finding in practice that people are now much better than they used to be about keeping this a sensible, civilized part of the process. It's so important in my view that parties at least see that they're all in the metaphorical room, in the metaphorical building, because otherwise you as mediator realize they're all here, but they don't necessarily think, well, you know, have they gone home now? Are they still here? Did they ever arrive this morning? All those sort of practical questions. So that's a psychology question, I think.
Thank you. And I love the sort of speed dating analogy and just how the mediator, especially at the start, that first hour, where you're really having to, you know, you don't know, they don't know you, you're sort of convincing them as well. And also just, these are the ways we're going to play it, these are the rules, and sort of being that sort of fair person with that as well.
But it gives you the ability to then say, as I said at 9:30, blah, blah, blah. Whereas if you're suddenly saying it, okay, that's
it's sort of let me find you this random rule of squash at this point. It's easier to set it up. Great. I am going to go to Amrik now, and we're flashing forward slightly further into the mediation and into the bit where actually often I think people can find this quite challenging, the offer stage. What should, you know, you work as a mediator, you work as a lawyer, what should the lawyer be thinking about when sort of making offers and sort of working with a client on that?
So I guess I wanted to start by just making this kind of rather general point, which is that as a lawyer, I think your role changes as you go through the process of mediation. And so the way I try to characterize this, or when Frederick asked me to talk about this topic, was think about how that role of the lawyer might change. So, for example, at the start of the mediation, perhaps in the joint session, you're probably acting as the party representative, maybe even as the party advocate, because you're basically representing them in the context of the case. I think when you get to the negotiation phase, though, I think what happens here, and what I see work really well in practice, is where the lawyers have the ability to switch from that role to being a trusted advisor to the client. And if they're being a trusted advisor to a client, whilst the merits of the dispute, you don't forget those, clearly you don't. But they take a little bit of a backseat role, because now you're thinking about what's important to the client and how, as a lawyer, can I help them to go on this journey through the negotiation phase and get to something that they can live with. I found this really, really hard when I was in private practice. It took me years to really remember that I'm no longer acting as the client advocate and fighting on every point with the mediator at every possible opportunity, because if the mediator agrees with me, then he or she is going to tell the other side how great my case is and how rubbish their case is, which of course in the real world doesn't happen. So I think this idea of trusted advisor is something that I want to focus on here, because I think what that does is it made me as a lawyer, so hopefully other people may agree with me here, may disagree with me, but it makes me think, actually, what's the conversation I'm now going to have with my client, either when the mediator is in the room, or what often happens is the mediator brings an offer into the room or asks for an offer, and then you kind of think, well, can you go away while I talk to my client about it? And what's my mindset going to be? And if my mindset is, well, I'm here to fight the case, does that take me somewhere else? Or do I really want to be thinking about what's important to my client here and how can I help them as a trusted advisor? So thinking about the alternatives if it doesn't settle. You know, what's the best alternative? You've all heard about this, the BATNA. What's the best alternative to the negotiated agreement? Or what does that mean in terms of their business? How is this deal, if it happens, going to help them? And how do I bring that to life so they feel as though they're doing something which they can be comfortable with, isn't necessarily just kind of giving everything away, or because they may not be particularly familiar with the process of mediation, so they need somebody to lean on here to give them that reassurance that what they're doing at this point makes business sense from, you know, with a quasi legal angle to it. So I think this notion of being this trusted advisor takes you into a different place as the lawyer. You stop thinking as a litigator and you start thinking about what does my client really want and what do they need from me here? So if, for example, me say, look, you're going to win at trial, is that really the best thing they can hear from me right now? Or do they need to hear something else about, well, actually, if you settle today, then that will enable you to do this. And from a legal perspective, that kind of makes sense because you can start bringing in conversations about risk, because there's no such thing as a risk-free case. And every lawyer in here will agree with that, because if I asked every lawyer in this room who represents clients, okay, you think you've got a surefire winner, put a percentage chance of success on that, I know what the answer to that is, and it's not 100%. So there's always risk in every piece of litigation. So if you start thinking about that as a lawyer and start talking to your clients about that, I think that takes you into a different place from being a party.
And as a sort of short question on that, with the sort of and sort of thinking about that, I mean, as the mediator, are you having those? How would you have that conversation with the lawyer? I haven't prepped you for that one, but how would you have that?
Well in a way, this is a great question. Exactly the point, because what you're doing in those private sessions when you're talking about the transition from exploration to settlement is, okay, so what do you want to do about the problem? And you engage with the lawyer on this, you bring the lawyer into the conversation. One of the worst mistakes I ever made when I was still learning my trade as a mediator was forgetting to engage with the lawyer, because the lawyer knows the client much better than I do, understands how they work, how they think. And if I can get them into the same space that I want to be in, which is commercially, how is this going to get sorted? And what are they bringing? Because they're bringing risk in. This person has been advising them possibly for years and years and has told them certain things, or she has told them certain things about what might happen. So the idea that somehow you can exclude them from this conversation and they're going to make a decision about how they settle the case without engaging with that lawyer is fanciful. So what I want to do is make sure that when I leave that room, I know that the lawyer, as much as I possibly can influence them, is not going to be saying to the client, look, don't forget about this, you're going to win a trial. And I know they're not doing that, but actually, yeah, okay, let's just think about how this might play out, what's important, and actually turn the conversation as to what's important and how they can try and help them to become that trusted advisor. And I think as a mediator, you can influence that. Ultimately, you can't control it, but you can certainly influence it.
Thank you. And finally, Amrik, just on the, so we're in the offer stages, and again, we're sort of thinking that maybe on the other side, there are lawyers not as amazing as the lawyers in the room, but you get an offer and this is not a great offer that you're receiving. What is the best way that a party can sort of signal or respond to a poor, in their eyes, poor offer?
Well, again, I think lawyers have a really, really important role to play here. The reality of life is, if we're talking about first offers, for example,
yeah,
the chances are the first offer that comes into the room from the other side is not going to be an offer that you like. So in one sense, I think if you're the lawyer advising the client, you might already have had that conversation with the client to say, look, don't be surprised if the first offer is not something you like. It might even be an insult. But don't let that necessarily take you away from the end game, because you're on a journey here. And you can perhaps talk about the idea, the notion that mediation is almost, it's not a game, but it is a bit of a game in the sense that you have to go through a process, and that process has to start somewhere. So the chances are you're not going to like what you hear, but actually, if the lawyer is constantly talking to the clients about, look, the important thing is what happens at 10 o'clock at night or 8 o'clock at night when you get that final offer. You're never going to accept the first offer, even if it's a brilliant offer, because instinctively you're always going to think there's more. But what you need to make sure is that you're taking that client through the journey that makes sure that the final offer that they get is the best possible offer that's going to be available on that particular day. And therefore, not letting the client get sucked into thinking, oh, because that offer is so low and it's coming so early, there's no point to that. And reminding them that the process is a tried and tested process. It's kind of why it takes the time that it does. So we're not there just for the sake of it. Sometimes there is a journey to be gone through. So I would kind of focus on that.
Great. I'm gonna
Just
yes.
Can I turn one comment to that? I agree with all you say, Amrik. You might think I'm an amateur psychologist. I think probably as a mediator, you do need to be an amateur psychologist. So when that first offer comes in and you as a mediator are thinking, my word, this is a challenge. What I think the mediator can do, and can do this, I think, successfully at this stage, at this early stage, is to say, I am the servant of the process. If you say to me, you want me to go into the other room and offer them, 3 shillings and 6 free decimalisation, then I'll do that. But I've got the right also to test drive that with you now before that becomes a publicly available offer. And how do you think they're going to react to this? What's your next step if they walk out, which is possible, although in my experience, very rare at that stage, actually, funnily enough. So if they walk out, what are you going to do? How are you going to report back to your chairman? What are you going to do, etc., etc.? Test drive it with me. And quite regularly, actually, people have gone in at a very low, trying it out sort of level, because tactically they think that's right, and it may well be right. But if I, as a mediator, say, I'm on top of my wall and I'm seeing and hearing things, I've read all the papers, how do you think that's going to play in the other room? You have an opportunity now, just because we are confidentially having this discussion in a privileged environment, you have the opportunity now to test drive that with me as a mediator, particularly that first offer, which can set the whole tone of the rest of the day. Then people say, yeah, that's actually really interesting. So give us 10 minutes, Andrew, and they come back and they actually improve or change the offer. And that gives me more scope to make some progress. So that's why I call this a psychology process as much as anything else.
Thank you. We're going to open up to questions in a second. I just want to, just before we do so, please submit them to chat if you're on chat, and be thinking of them if you're in the room, if you haven't already. I do just want to just do the bit that's always tricky, which is a deadlock. We get to that or something like that. And actually, maybe Suzanne, did you have any views on what lawyers particularly, or what you should do if there's sort of a, you're getting to several offers or there is deadlock or that sort of process?
I mean, I think one of the things that we often see is that people frame offers based on the way they look at the dispute.
Mm-hmm.
So the first few offers are often framed around the view of the dispute, packaged in all sorts of different ways. And I do think it's helpful to have a justification, even if it's reverse engineered to the extent possible. And then you'll get to maybe a certain point where you want the other side to accept the way you view the case,
mm-hmm.
but they don't. And I think that's where having built a relationship between the mediator and the party, but also the lawyer, can be helpful, because in those situations, a lawyer will often be saying to the clients, yes, they're not accepting the way we see this, let's reformulate the way that we're making these offers to engage with what they're saying.
Mm-hmm.
And they will usually be doing that as a result of me suggesting that. And that can really help. But I think also working with your own client to work out what might be the obstacles that they have to overcome
mm-hmm.
to reach a resolution. So, for example, I worked on a dispute a few months ago where the client was being sued on their reps and warranties. They sold a business and they were being sued because they were basically being told they were liars and they lied in their reps and warranties, and they really didn't think they had lied. And so we were getting to a point where they couldn't accept the idea that they would make offers over a certain amount. Ultimately, they're kind of 30% risk because they didn't think they'd done anything wrong.
Yeah.
So pausing and discussing with them, okay, so you've sold this business at this point, things have happened in the last year, which mean that arguably it is worth less. You haven't had to deal with those challenges. But if you had sold it a year later, would you have got less for it? Yes. Would you therefore maybe be able to think of it in a different way? And you could see the penny dropping of this person who suddenly was saying, yes, I want to extricate myself from this, and I can offer them this because that's what I would have sold the business for at this point in time, and then I'll be able to extricate myself. So working with your clients to try and work out if there's space for them, but also thinking about what might be possible in the other room that would be able to influence them if you were able to repackage the offer. I think it's on both sides in terms of working with your own client to see if they can shift the way that offers are being made to break through the deadlock, but also thinking about what you might be able to do to reformulate offers so that in the other room, that deadlock can be overcome.
Brilliant. And we always hear about, bashing someone in the head to get them to accept your offer is hard work. It's very tiring, not particularly pleasant, and really are trying to persuade them to accept it, and
Yeah.
sort of say, sort of how are you reframing that, and actually, and also you sort of talking about expanding it as well in terms of the theoretically and conceptually, so that they're
Yes.
finding that sort of life raft off where they are stuck.
Exactly. And I think listening to what the mediator is telling you about what the other side is saying about your offers, so that you can use that intel to work out where you want to go with things.
Brilliant. I want to open up to questions. I can see we've got some questions online, and so Andy Rogers, did you get some questions from the audience?
Yeah, I'm just going to do a brief summary because we've had many questions from the 100 or so people we've got online. There's lots of comments in relation to the importance of education for lawyers and experience. But I'll pick a couple of main themes, and also possibly with the panel's agreement, because there are so many questions online. We'll circulate some of the questions after the event, and then we can kind of send a mail to people with some of the answers. So there's a question on materials in preparation for the mediation. Terry Jones, who was getting on an EasyJet flight, wanted to ask a question before he flew, which was how important is a joint statement from the parties? And then Anna Bauder in New York added to that, what do you do when you as the mediator actually know enough to actually create a joint statement, but the parties won't talk to each other? Another point that came up online, sorry, I've got so much, I'm going to refer to my notes, was how can success stories in mediations be shared more between mediators, so they have more idea of strategies and what paths to success will look like? What can be done to stop lawyers from just repeating the pleadings in an opening mediation session? And is there a way of getting the clients to take the floor in that scenario? And
Can we take that question just as one, because I think it's one that we've experienced, and you sort of know the one, and even actually you have the conversation with the lawyer, and then they turn up, and it's sort of, you know, I don't know, Judge Rinder on acid has turned up, and sort of we're in the room. Does anyone on the panel have a tip for how you actually talk to the lawyers and avoid them just doing pleadings? And Emma, did you or?
Well, I am seeing things improving. I don't know about the rest of the panel. I think there's less of that than there used to be, certainly. I think there are two questions here. So that there's the what happens in the written kind of position statement or case summary. I'm finding less and less they are reciting the pleadings, which is a very welcome development. And I've seen some excellent ones recently where actually they've been much more focused on the commercial drivers and even sort of suggesting possible paths towards building a sector, which is a really welcome development. And then in the actual joint meeting itself, I do a lot of preparation, very much like Suzanne was saying. So I pretty much know before we go in there what people are going to say. I mean, they may still surprise me, but I know what they're going to say. We discuss the importance of being collaborative. We might even role play it a little bit if we want to. We're going to talk about how that statement might land with the other party. And so I've got a pretty good idea, just as you were saying, Suzanne, about how that's going to go before we step in, and so does everyone else.
Brilliant. And I think just on, sorry, did you have a?
Yeah, well, I would just add that as a mediator, I do always encourage the lay client, the main witness, the managing director, the chairman, whatever it may be, to actually say something in that opening session, assuming we're having an opening session. We've already gone through that process. So we're having an opening session. The case summaries have been exchanged. I always encourage people to confine their comments to what has come out of the other side's case summary, as opposed to rehearsing again what their own case summary says. That's a sort of triumph of expectation over hope, probably, or is it hope over expectation? I don't know. Sometimes it works. And then I do encourage the lay client or the lawyers to encourage their lay client to say something in that opening session. It's very interesting how fashion ebbs and flows on that. So when I first started as a mediator, that was, whoa, we're not going to do that. Then it became more common, perhaps. Now I'm finding that people have prepared statements. as the principals. So they de-risk the concern that someone's going to go off on one and make an exception that is going to be used on a Part 36 offer at some later stage, which is a risk. I accept that. So I think a prepared statement, but simply the psychology of being there in the room with your opponent as the principal. I'm invested in this process. I'm here. I'm given a day of my time to be here. Is, I think, quite a powerful. If you can make some comments that your lawyer is happy with because the lawyer has seen the script, then I think that's a win-win.
Just to very quickly, on the point about lawyers reciting the pleadings, whenever I've seen that happen, I've never yet had a case where the lawyer does that, the other side in the joint session says, well, of course, now I've heard it like that, you're right. This doesn't happen. Even if they did agree with them,
Just recite
they wouldn't tell you.
Yeah.
So what's the point?
You want to avoid eye rolling on the other side. That's never a good one. Do we have any questions? Thank you. Do we have any questions from the audience? I know we may have some more. Is there anyone in the in-person audience? Yes.
If lawyers walk in with their pleadings, reciting them, do you remind them that this mediation is not about legal rights, rather about commercial interests? And even though they might have a good legal case, so what? At the end of the day, isn't life much more important? And selling widgets much more important than asserting your legal rights?
Well, I mean, I couldn't agree more. And actually, the conversation, I think, as Suzanne was saying, and Andrew was saying, the conversation that you have pre-mediation will hopefully set that up, and you kind of play that out with them beforehand. So by the time they come to the day itself, that's hopefully not where they're starting. And I come back to my point about, are you being there an advocate for your clients, or are you being a trusted advisor? And actually, what do you want to be?
Commercial advisor rather than a legal
commercial
advisor, yeah.
trusted advisor, yeah.
Selling widgets rather than
Yeah.
selling your time in court.
And I think we talked about this earlier as well in terms of what the mediator is doing and their role. And Emma, I know you were sort of talking about, the mediator. You didn't use this phrasing. The mediator is not an idiot. The mediator is not there to sort of say you've got no. Do you want to explain about your sort of view, like how the mediator, in terms of being neutral, but also not, they have legal rights. They have how you would.
So from my point of view, and you may not agree with me, I think the commercial drivers are super important. So yes, I think that's where the focus should be, but the legal case, from my point of view, isn't irrelevant. And the reason for that is that the client has to weigh up the settlement that's on the table today with what the alternative looks like, which usually will be going to trial. And they need to weigh up the win scenario against the loss scenario. And to do that, they've got to have a pretty good understanding of how good their case is. And that's where your lawyer, as a lawyer and as a trusted advocate, I think comes in and has a powerful role to play. But I think that we do also have a role as mediators in that, as well as part of that testing process. So I will ask in my initial call and in my private meetings with the client and the lawyer what they see the challenges in their legal case are, because I think we've got to realistically assess what our prospects are before we can weigh up the settlements on the table today. The situation I was talking to Frederick about earlier was a really interesting one, because in that case I didn't have to foist my that analysis onto the mediation party at all. It was an in-house lawyer actually who said to me, what I really need in the private meeting is for you to throw some rocks at my case. She said, because I'm just not sure what I'm missing. So can we actually sit down together and go through what the other side might argue if we ended up going to trial? And there, I think as mediators, we do have a role, not to advise or to evaluate, but to say, well, if this went forward, then this potentially is what the other side could argue, and to wrap that up in your consideration of any second.
I think that in the first part of any mediation, you're often seeing the lawyers trying to work out if there are pieces that they have missed. And they're trying to invite that challenge from the other side and from the mediator, obviously in a way that doesn't make them look bad in front of their client, but they'll be saying, is there something that we've missed? And they'll be saying, well, have they explained how they take this position on X? And they're trying to work out where the risk position lives now that they're in the mediation. And in fact, they're doing that throughout. So as information comes in and as offers are made, I think the lawyers, the good lawyers who are the trusted advisors, who are thinking about the legal aspect, but also about, you know, the commercial considerations, are working out, well, now is my client in a better position with all this knowledge than they were before, and are the offers that are being made aligned with where we now think the case is, both in terms of the strength of the legal case, but also whether the other side is going to pursue everything through to trial, what their appetite is, all the different moving parts a good lawyer is thinking about and helping their clients navigate.
Fantastic. So the lawyer is sort of constantly working, unsurprisingly, and also that the mediator as well is aware that this is what the lawyer should be or could be doing at this point as well.
Yeah.
And I'm hearing just lots of really interesting things. We are with the bells and symbols sort of at time, but I'm just going to sort of, I mean, is hearing lots of sort of points from everyone about sort of the lawyer being strategic throughout as the mediator working, and sort of really that's from the first phone call, that sort of, you know, the speed dating. This is perhaps even before the speed dating moment. You know, you're there, you know, finding the profile of the mediator and sort of doing those initial things, making the right first impression. You talked about sort of really, as a mediator, being strategic as well, and working with the parties and sort of doing the joint sessions. Actually, possibly going with some stuff as well. If the lay client may actually take it in a different direction than you're expecting, working with that and holding it, and sort of also about offers as well, and sort of being effective on that. What I'm going to ask the panel is if they could all just, if they had one final thought, top tip, comments, what would you sort of say for sort of working with lawyers in mediation? I'm sorry, we're going to start with you, Emma.
So I'm actually worried I'm going to steal someone else's, so apologies Tim if I do. For me, yes, preparation is really important, but I think that as lawyers, and as mediators as well, we have to be really fleet of foot in the process as well. We have to be agile. We need to be prepared to change our mind and what we might be prepared to settle at based on what we hear, based on how the process goes and how we might choose to adapt that. So it's being prepared, but being agile and ready to shift position and use that process really flexibly.
Thank you, Suzanne.
I completely agree with that. What I do think about in terms of mediation is that people that settle because they've managed to formulate a narrative or a story about why they've settled and what they've settled for that they can live with. And so as a lawyer, you're helping your client to formulate that narrative. As a mediator, you're helping both parties to formulate that narrative. But you've also got to be cognizant that the other side has to live with their own narrative. So you're constantly, I think, helping that process through, aware of the fact that it's confidential, but invariably there's somebody they will tell.
There's a story
about this story, and they want to come out looking good to themselves and to that other person.
Fabulous, thank you. Andrew.
Well, we'll come back to my P word again, which is preparation, I guess. I mean, there's a danger that preparation sounds slightly boring, but actually preparation, in my view, half of the value of a mediation happens in the time before the 9:30 clock starts to tick on the day of the mediation. So it's, who am I going to have as mediator? What am I going to say in my case summary? What am I going to say to the mediator when we have our private discussion ahead of time? How am I going to make progress, which means we can hit the ground running at 9:30 as opposed to starting to talk at 11 o'clock or whatever it may be? And what's in the other side's mind? What are my clients' aims and objectives? What are the other side's aims and objectives? And really high quality brainstorming with your client as the lawyer in a mediation before you even get to the 9:30 clock starting to tick is so important in my view. And actually it's so important on a number of different levels. So the most practical thing is if you have not spotted an issue that the other side ram down your throat as a lawyer at the mediation in the opening session or whatever it may be, or the mediator on their behalf has their authority to make a point in the room. The last thing you want to do as a litigation lawyer is to be embarrassed in front of your client, because you lose a certain amount of momentum at best. And so thinking it through, not just saying this is what the pleadings say, but what are the real core issues here? Where are our strengths? Where are our weaknesses? Taking your client with you along the path so there are no surprises during the course of a mediation day, I think pays dividends.
Thank you. And finally, Amrik.
So I don't know how I'm going to be able to say anything that isn't a repeat of what the rest of the team have said. So if I can give you an anecdote, so perhaps this maybe brings it all to life. One of my best experiences when I was in private practice was I did a mediation for a client where a very senior executive of the company turned up to the mediation who I had never met before, and nobody from my firm had ever met before, but was a serious decision maker. And the feedback that I got from that person after the mediation was that they had met a lawyer who really understood the commercial imperatives of the business, which a few years later resulted in me becoming the client partner for that client, even though I was a litigator, not a transactional lawyer. And most of the work was transactional work we did for them, because I was able to sort of develop this relationship with them at the mediation day, where I got a day with them, talking to them about all kinds of stuff, as well as the mediation day. So there is a great opportunity to engage with your client at a mediation, because you're not always talking about the case on the 10 hours that you're there on the day. So there's a little bit of an anecdote which kind of brings to life some of the points that these guys are saying as well.